Hi friends, good morning. In continuing with our conversation on fundamental rights under our constitution, today's focus is on Article 25 to 32. Thanking Deepika and Jugal who have helped us get the presentation for us today. These are some of the terms used. I think we're familiar with them in our earlier conversations as well. So the agenda is first about a brief overview of all these articles. Then some of the controversial topics of today's times: the right to freedom of religion, exemptions from taxes, cultural and educational rights, saving of laws. So these are laws where you will not have, uh, I believe, ideally a constitutional remedy, and right to constitutional remedies. Quickly understand this is the overview: freedom from conscience and of free provision, free profession and practice of religion, freedom to manage religious affairs, freedom as to payment of taxes for promotion of any particular religion, freedom as to attendance at religious instruction or religious worship in educational institutions, protection of interests of minorities, right of minorities to establish and administer educational institution, right to property is of course omitted now, saving of laws providing for acquisition of estates, etc., to abolish zamindari system, validation of certain acts and regulations, saving of laws giving effect to certain directive principles, again remedies for enforcement of rights conferred by this part, constitutional validity of state laws not to be considered in proceeding under Article 32, of course, that's now stands omitted. So, right to freedom of religion, Article 25 to 28. Let's quickly look at them before we understand, analyze these articles. So, Article 25 and 26, subject to public order, morality, health, and to the other provisions of this part, all persons are equally entitled to freedom of conscience and the right freely to profess, practice, and propagate religion. Nothing in this article shall affect the operation of any existing law or prevent the state from making any law regulating or restricting any economic, financial, political, or other secular activity which may be associated with religious practice, or providing for social welfare and reform, or throwing open of Hindu religious institutions of a public nature character to all classes and sections of Hindus. Subject to public order, morality, and health, every religious denomination or any section thereof shall have the right to establish and maintain institutions for religious and charitable purposes, to manage its own affairs in matters of religion, to own and acquire movable and immovable property, and to administer such property in accordance with law. When we look at the meaning of the definition of the term religion, the Constitution, however, doesn't define it anywhere, but the Honorable Supreme Court did give a fairly comprehensive dispensation on that term in Commissioner Hindu Religious Endowment versus Sri Lakshmindra Tirtha Swamiyar of Sri Srirur Mutt in the following words: religion is a certain matter of faith with individuals or communities, and it's not necessarily theistic, which theism is belief of God, belief in the existence of God. Uh, there, there are well-known religions in India like Buddhism which do not believe in God or in any intelligent first cause. Religion has its basis in a system of beliefs or doctrines which are regarded by those who profess that religion as conducive to their spiritual well being, but it would not be correct to say that religion is nothing else but a doctrine or belief. A religion may not only lay down a code of ethical rules for its followers to accept, but it might prescribe rituals and observances, ceremonies and modes of worship which are regarded as integral parts of religion, and these forms and observations might extend even to matters of food and dress. Moving on, now freedom of conscience and free profession, practice, and propagation of religion. So, Articles 25 and 26 embody the principles of religious toleration that has been the characteristic feature of the Indian civilization start right from the beginning of our history. They serve to emphasize the secular nature of the Indian democracy, which the founding fathers considered should be the very basis of the constitution. While Article 25 of the Constitution guarantees rights to an individual, Article 26 guarantees rights to an organized body of individuals like the religious denominations or any section of them. And both these articles protect matters of religious doctrine or belief, as well as activities done in pursuance of religion, rituals, observance, ceremonies, and modes of worship. However, what we also need to understand that is Article 25 and 26 are not absolute rights. Therefore, there are instances where these could be regulated, and both these rights are subject to public order and morality and health, and to other provisions of fundamental rights. So, Article 25 of the Indian Constitution, of course, guarantees to every person and not merely the citizens of India the freedom of conscience and the right to freely profess and practice and propagate any religion. It empowers the state to make laws regulating or restricting economic, financial, political, or secular activity pertaining to any religious practice, and laws providing for social welfare or reform, even though these might interfere in religious practices. And a religious denomination is a collection of individuals, typically the case of a mutt or a masjid, classed together under the same name having a common faith. Article 26 provides that every religious denomination shall have the right to establish, maintain its institutions, manage its own affairs, own and acquire movable and immovable property, and administer any such property in accordance with law. Now, moving further, Article 27 and 28. No person shall be compelled to pay any taxes, the proceeds of which are specifically appropriated in payment of expenses for the promotion or maintenance of any particular religion or religious denomination. Further, no religion instruction shall be provided in any educational institution wholly maintained out of state funds. So, which is why you would see even under income tax law, the definition of the term charitable purpose under section 2, subsection 15 does not include the term religious purposes. Nothing in clause 1 shall apply to an educational institution which is administered by the state but has been established under any endowment or trust which requires a religious instruction shall be imparted in such institution. And no person attending an educational institution or any educational institution recognized by the state or receiving aid out of state funds shall be required to take part in any religious instruction that may be imparted in such a place or attend any religious worship that may be conducted in such institution or any affiliated premises, or if such person is a minor, his guardian has given consent thereto, cultural and educational rights. So technically, you cannot enforce upon religious curriculum in a state-sponsored institution. Exemption from taxes and prohibition of religious preaching in state educational institution. Again, you cannot exploit the population by collecting taxes for the purpose of application towards a specific religion. No person shall be compelled to pay taxes or expenses on promotion or maintenance of any particular religion, and this again is in tune with the concept of secularism. Similarly, Article 28 restricts any kind of instruction or religious preaching in any educational institution wholly maintained by state funds. Now, if we were to look at some of the interesting decisions or relevant decisions in this regard, in the case of Sri Jagannath Temple, the Puri Management Committee versus Chintamani Kuntiya, the Honorable Supreme Court held that although the state cannot interfere with the freedom of a person to profess or practice any religion, the state can control the secular matters with all activities in or connected with the temple. And in another case of Maulana Mufti Syed Morur Rahman Baskati, the state of West Bengal, the question of using microphones and loudspeakers outside mosques arose, where the Honorable Court, categorically stated that the prohibition of use of loudspeakers during azan is not violative of Article 25 of the Constitution in the light of the term public order which is being used. Similarly, in the case of the recently popular case of Indian Young Lawyers Association, was a state of Kerala, where the Supreme Court where the Supreme Court was asked to decide on the entry of women in Sabrimala temple. It was a very interesting and a very controversial case. The Sabrimala temple is a temple at Sabrimala in Pathanamthitta district. In the past, women devotees of menstruating age were not committed to worshipping here, as there was a ban, and which is said to, and this ban being said to be out of respect to the celibate nature of the deity in this temple. In September 2018, the Honorable Supreme Court ruled that all pilgrims, regardless of gender, including women in the menstruating age, should be allowed entrance to Sabrimala. The Constitutional Bench of the Supreme Court held that the exception to entry of women because of biological differences violates the Constitution, and that the ban violates the right to equality under Article 14. It was further held that the practice violated the fundamental right to freedom of religion of female workers, worshippers, guaranteed under Article 25(1). However, now a review petition has already been filed, and uh, the proceedings would start very soon in that direction. Cultural and educational rights, Article 29 and 30. Any section of a citizen residing in the territory of India or any part thereof, having a distinct language, script, or culture of its own, shall have a right to conserve the same. I mean, the reason why the Northeast India is having so much of concerns against Citizens Amendment Bill is because of its preservation of culture. And it's an absolute right for the minorities to preserve its language and culture through educational institutions and cannot be subject to reasonable restrictions in the interest of general public. Similarly, no citizen shall be denied admission into any educational institution maintained by the state or receiving aid out of the state funds on grounds of only religion, race, or caste. So very clear. Any public funded institution has to be secular in nature. So, what is the essence of the right guaranteed under Article 30? All minorities, whether based on religion or language, shall have the right to establish and administer educational institutions of their choice. The state shall not, in granting aid to educational institution, discriminate against any educational institution on the ground that it is under the management of a minority, whether based on religion or language. So, if you look at an interesting judicial precedent here, in the case of St. Xavier's College was the state of Gujarat, the court held that the right to administer is the right to conduct and manage the affairs of the institution, and elaborated on the meaning of the word administer. And administer means right to manage and conduct the affairs of the institution. And it is open to the university to impose reasonable restrictions or conditions on a minority institution for maintaining the requisite educational standard, like qualification of teachers, conditions of service, qualification for students to enter, etc. So, if you were to look, if a minority religious community wants to start an educational institution to provide higher secondary education, can it do? Yes, it is a right of the community to start any institution under Article 30. Now, let's look at saving of law. Now, this is interesting because these are scenarios where you cannot seek out for remedies under the Constitution. Article 31A, B, and C. Notwithstanding anything contained in Article 30, no law providing for the acquisition of any estate by the state, taking over the management of any property by the state for a limited period, amalgamation of two or more corporations in public interest, or secure the management of any corporation, extinguishment or modification of any rights of managing agents, secretaries and treasurers, MDs, or managers of corporation or of any voting rights thereof. Which effectively means, when we look at it, by the first constitutional amendment of 1951, the parliament added this section, and accordingly, the government can acquire the right of property of people, uh, which also is, uh, and by doing so, the fundamental right, which is right to equality and freedom of speech of the institution of the Indian Constitution, shall not be violated. So, Article 31A categorically states that this particular article or laws made under this article are immune to Article 14 and 19. And so, if you look at it, friends, when the zamindari system was there, huge pieces of land were owned by very few set of individuals, and the government forcefully acquired these lands. They brought in land sealing provisions under various formats. But the primary intent was equality in distribution of wealth. So, under such circumstances, you cannot invoke the provisions of Article 14 or any other provisions of the Constitution by virtue of Article 31A. Similarly, when we look at Article 31B, without prejudice to the generality of the provisions contained in 31A, none of the acts and regulations specified in the ninth schedule or any of the provisions thereof shall be deemed to be void or ever to have become void on the ground that such act, regulation, or provision is inconsistent with or takes away or abridges any of the rights conferred by any provisions of this part, and notwithstanding any judgment, decree, or order of any court or tribunal to the contrary, each of the said acts and regulations shall, subject to the power of any competent legislature, to repeal or amend or continue in force. So typically, what happens now, consequent to the First Amendment of 1951, where this Article 31A was introduced, in order to protect laws which are being introduced consequent to 31A, 31B was introduced, and it's in reference to the acts and laws mentioned in the ninth schedule of the Indian Constitution, which contains a list of acts, over 100 acts and laws, which cannot be challenged in the court of law, which effectively means such acts mentioned in the schedule are outside judicial review. And Article 31B states that the provisions mentioned in 31A are immune from Indian judiciary and cannot be annulled on the basis that they might violate the fundamental rights. This was challenged in Vaman Rao versus Union of India, where it was held that acts and laws mentioned in the ninth schedule till date shall not be challenged, changed, or challenged, but any amendment or any addition or any more acts to that schedule will suffer close inspection and examination by the judiciary system. This was done to protect the basic structure of the constitution. And when you look at most all the acts under the ninth schedule, all these are for solving a larger social problem. Your Tamil Nadu land reforms, Bihar land reforms, Madras land reforms act, the AP land reforms, Kerala land reforms. So all these you would notice by and large were for equality in distribution of wealth. Similarly, when you look at 31C, notwithstanding anything contained in 13, no law giving effect to the policy of the state towards securing all or any of the principles laid down in Part 4 shall be deemed to be void on the ground that it is inconsistent with or takes away or abridges any of the rights conferred by the Article 14 or 19. And no law containing a declaration that it is for giving effect to such policy shall be called in question in any court on the ground that it does not give effect to such policy. Again, when we look at it, 31C was introduced through the 25th Amendment of 1971, through which the government tried to give priority to few of the directive principles of state policy. And 31C aims at two primary objectives. Any law made in pursuance of Article 39B and C. When we look at Article 39B, it states that it talks about ownership and control of material resources of the community are so distributed so as to best subserve the common good. And 39C states that operation of economic system does not result in concentration of wealth and means of production to the common detriment. So any law in consequence of 39B or C of the Indian Constitution will avoid scrutiny of courts even if it violates Article 14 and 19 of the Indian Constitution. Courts will not have the jurisdiction to decide whether the law enabled really gives effect to the principles mentioned in 39C and B because it is outside their perspective or purview. Right to constitutional remedies, Article 32. So the right to move to Supreme Court by appropriate proceedings for the enforcement of rights conferred by this part is guaranteed, except 31 ABC. The Supreme Court shall have the power to issue directions or orders or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari, whichever may be appropriate for the enforcement of any of the rights conferred by this part. Now, without prejudice to the provision, powers conferred on the Supreme Court uh, by clause 1 and 2, the Parliament may by law empower any other court to exercise within the local limits of jurisdiction all or any of the powers exercisable by the Supreme Court. The right guaranteed by this article shall not be suspended except as otherwise provided for by this Constitution. So, It's a right by which any citizen can apply to the Constitution, or any person can move to the Supreme Court to apply the Constitution or to uphold his constitutional rights. So, besides making provisions for various types of fundamental rights, the Constitution has additionally provided for an effective mechanism for protection and enforcement of these rights. Article 32 states that a person can move to Supreme Court if he or she wants to get their fundamental rights protected. Even the right to protect the fundamental rights of citizens has itself been made a fundamental right, which is named as a right to constitutional remedies. Article 32 guarantees this right to move to Supreme Court by appropriate proceedings for the enforcement of fundamental rights contained in Part 3 of the Constitution. Thus, the Indian Constitution has made the judiciary the guardian of the fundamental rights of the people. The Honorable Apex Court is given the authority to issue directions or orders for the execution of any of the above rights bestowed in the Constitution. Which is why you would see sometimes when there are tax proposals which prima facie look to be uh, hypothetical. Classic example is Section 50C of income tax, which focused on deemed value taxation. The section was constitutionally challenged. And the fact that there was a remedy available within the section to ensure unjust practices are not adopted, the provision stood the test of judicial scrutiny. So, this is a scenario where whenever someone's constitutional rights are being threatened, obviously they have a mechanism under Article 32 of the Constitution. So, these were some of our thoughts, friends, on this very, very relevant and pertinent conversation of our times about the fundamental rights. So, we've had a discussion from Article 25 to 32. Hope to catch up with you sometime next week on another conversation of relevance. Thank you.